Hi there, I'm Jessica Eves Matthews from Leverage Legal Group, and I'm excited to have you join me for this webinar. To give you a little bit of background about me, I am the founder of Leverage Legal Group, and I am a business and intellectual property lawyer, trademark lawyer, actually. I'm a author of a best-selling book called Wonder Women: How Western Women Will Save the World. It's about women entrepreneurship. I am a speaker and busy CEO, and my passion is helping entrepreneurs uh, really step into their power and create brilliant businesses without fear and without undue risk to their assets or hard work. I've been a lawyer for almost 22 years. I spent my legal career representing businesses and business owners, from solopreneurs to Fortune 500 companies and some of the most successful entrepreneurs in the world. I've been the head of litigation and compliance for Paul Allen, who was the co-founder of Microsoft. And I really have been there for every phase of the business lifecycle from startup on. And my firm, Leverage Legal Group, provides flat fee, world-class legal services designed specifically for busy entrepreneurs and founders. And we also have another company called Leverage a Lawyer, which is really for startups with no legal budget or very little legal budget. And we provide self-help legal guidance through excellent contract templates, information, and support. And I just want to say before we get started that I have to give my lawyer disclaimer here that this webinar is not intended as legal advice in any way. It's really meant to just provide you with an overview and an education on which legal issues are critical for entrepreneurs to get a handle on and in order to protect your hard work. Every business owner, and I believe this very strongly, should have a strong relationship with a good business lawyer. And you really need to hire somebody who knows the law in your state as well. And obviously, we have experienced lawyers in many, many states and cities across the country, so we can assist you with our flat fee services if you're interested. But this webinar is really intended to give you a good framework to understand what it is you need to do to protect yourself. I always say that I like to talk about business brilliance. That's part of my brand. I do a lot of mentoring and coaching of business owners, and I use that phrase, business brilliance. And going into business for yourself is all about the pursuit of a positive work-life balance. It includes, a seeking of inner fulfillment and living life on your own terms. Obviously, there's an interest in making money. Sometimes there's an interest in making a lot of money and building an empire. The things people are seeking when they launch their own business can be different. Some are going to be empire builders with offices that span the nation or the globe. Others are going to be really happy just to remain small in their local area. And some will define success as a 7-figure enterprise or multi-7-figure or even 8-figure enterprise. Others will define it merely as being their own boss, no matter what their income. So in short, brilliance can really be defined as doing what you love to do, having time to be with your loved ones, and enjoying the freedom to pursue the opportunities that you're passionate about. The definition is really personal to you, your business, and what you consider to be success. But there's one more component to brilliance. Just doing what you love and hoping for the best is not enough to protect your entrepreneurial endeavor. It's not enough to protect you or your family. And the most critical part of being brilliant in business is making sure that you have a strong legal foundation on which to build your enterprise. This foundation must be structured in a way that maximizes your chances for success and minimizes common risks that can undo all of your hard work or, unfortunately, can even put you out of business. So much goes into starting and maintaining a successful business, and it's not really possible to address all of it here. However, understanding and avoiding the following 7 hidden legal disasters that we're going to discuss today will help you to start building a strong legal foundation that is so integral to a brilliant business and a brilliant life. So let's jump to the first hidden legal disaster in your business. It is not having a proper entity. I call this choosing an entity and setting it up ASAP. you may be sighing and cringing at the very idea of discussing legal ideas. And I'm really glad you're here, and kudos for deciding to tune in for this. For many people, it's really as exciting as watching paint dry, and maybe even as exciting as watching paint dry, maybe even less so. People usually want to focus on the more fun tasks of a business like social media, branding, promotion, etc. But first, you absolutely must get your legal house in order. Addressing the legal issues inherent in starting a business can be exciting, though, if you view it as another step in the path to your ultimate dream. After you've protected your assets and your activities and all of your hard work, you'll have the peace of mind that allows you the emotional and mental freedom to enjoy running your business. So the first hidden legal disaster that can hurt your business is failing to set up a proper business entity. Setting up this entity should be your first priority. A business entity is separate and independent from your personal identity. Those two words are very important. If you're going to write something down, write them down: separate and independent. Your goal throughout your day-to-day operations for your business should be to keep your business separate and independent from you as an individual. If your business is truly separate and independent, then your personal assets like your house or your car or whatever it is that you cherish are generally safe from business liabilities, though there are, of course, exceptions to this rule. Now, there are several types of business entities to choose from, but for a small startup, there really are only three basic choices. Number one, there's limited liability companies, also called LLCs. There are S corps, also called S corporations, and then there are C corps, which are the long name for that is C corporations, and that's what you think of when you think of a traditional corporation. What if you've already started your business and haven't set up an entity? Don't beat yourself up about it. Many small businesses operate as a sole proprietorship, and if you've never had any kind of entity set up, by default you are a sole proprietorship. But the problem with being a sole proprietorship is that you have absolutely no protection from liabilities that arise from your business activities. That's a really big deal, obviously. That means that if someone sues you to collect on a bill, for example, one incurred by your business, they can potentially access your personal property to satisfy that debt. You may lose your house, your car, or any other property in which you own equity. If you're in a community property state, creditors are also going to have access to community or marital property. So as you can see, there's a massive risk in operating as a sole proprietorship. And I always advise against that business structure. If you have a business partner and you haven't set up a legal entity, then you are by default a partnership. Just as a sole proprietorship, if you are a partner in a partnership, then you have total exposure to business liabilities for both yourself and your partners, no matter how many of them there are in your business. There are obviously costs involved in setting up an entity, but they greatly, in my mind, outweigh the risks of having no entity in place at all. Luckily, business entities are pretty easy to understand and set up, especially if you have a good lawyer. And we do have a service to help you do that in a pretty affordable way. But a limited liability company is the ideal choice for most small business owners. And that it's a great way to start because it gives you limited liability, just like it says. That does not provide you with absolute protection from liability. It's called limited liability after all, but you will have a lot of protection. You will also enjoy certain tax benefits, including what's called pass-through taxation. And what that means is that any revenue that comes into your business, the profits that result from that after your expenses are only going to be traced to your personal income tax level. So it's different from the tax structure of a corporation, for example, which is hit with what's called double taxation. So in corporations, the net revenue, that means after expenses are deducted, will be taxed on the corporate tax level first, and then any money you pull out of your company, such as a salary or a distribution to the shareholders, will be taxed again a second time. That same dollar, basically, same money, will be taxed again on your personal income tax level. So it's called double taxation. And that's one of the big reasons a limited liability is such a great choice when you're first starting out. There are really only, in my mind, a few situations where a C corporation makes sense for the startup business owner. One is if you intend to sell the business in the future. And even if that's the case, you can always convert to a corporation later, but you can sell an LLC. So that's not necessarily a good reason to be a corporation. The other is if you want to attract investors. That's a big one. Most people who are investing in a company do not want to do it in an LLC. In fact, most venture capitalists will require you're a corporation. Some angel investors won't mind that you're an LLC, but as a rule of thumb, you're going to need to be a corporation before you get investment money. So if you're going to be raising capital at some point in the form of venture capital, angel funds, or through selling shares on the open market, and that means even if you have a vision of going public and being traded on one of the stock markets, for example, then you really should bite the bullet and be a C corporation. There are some tax benefits to being a C corporation. And I always encourage you to develop, along with a relationship with a good business lawyer, I encourage you to develop a relationship with a good CPA that can help advise you on those tax issues. But generally, the tax benefits to being a C Corp for most small businesses are not significant enough to really justify the cost and the work involved in maintaining that entity. And as I said before, you can always convert your LLC to a C corporation later if the need arises. So you're not stuck with an LLC if that's how you start. The other entity is an S corporation or small business corporation. And that is actually really just a tax election. I have a lot of small business owners that ask me about this, and a lot of CPAs recommend this for their clients. And it is not an entity in and of itself that you form with the state. So when you first set up your business and form your entity, you're really going to be forming either a C corporation or an LLC with the state. And that's a whole other issue about where you file. And a good lawyer can help you make that decision. As I mentioned at the beginning of this, there are other entity forms, but generally for a small business that's just starting or a startup, even if you plan to get big, an LLC or a C Corp are going to serve you just fine. The LLC being the easiest to form, the cheapest to form, and the easiest to maintain. And you can always convert to a corporation after. But an S Corp is a tax election, which means that you're going to actually tell the IRS that you want to be treated as an S Corp. So you start out as either an LLC or a corporation first. And as an S Corp, you will still be taxed as a partnership as you would be with an LLC. That's the pass-through taxation that I mentioned. But there are significant tax savings in being an S Corp once you reach a certain level of positive tax cash flow for your business. However, you won't see much significant savings in self-employment taxes until you start making at least a six-figure profit. A CPA can guide you when to make that election. But the great thing about it is you can elect it later, so you can start out as an LLC and then make the tax selection for S Corp once it makes sense to do so. It's important to note the downside of being an S Corp as well. And this is true for C Corps also, but for S Corps, it's sort of a hidden trap, and it's one of the potential hidden disasters in your business. Once you elect with the IRS to be an S Corp, you have to maintain what are called corporate formalities, which means having annual meetings and minutes and corporate resolutions for every major decision. And you have to keep your record books in your place of business, and you have to be very meticulous with the paperwork. So it's a lot more work to maintain an S Corp than an LLC. So you really need to make sure you are going to benefit financially from having done it. The thing is, if you don't maintain those formalities and you get challenged by the IRS, you could lose that S Corp status and be barred from claiming it again for the next 5 years, even if you technically qualify for it. And by getting knocked back to your underlying entity, which is either an S Corp or, LLC or a C Corp, you could also face penalties and fines from the IRS because they basically disregard the S Corp status. And so then if you weren't filing your taxes in the right way, paying your taxes in the right way, then the IRS will treat you as if you should have done that in a timely way, and you could be penalized for not having done it. So there are definitely some traps for the unwary with the S Corp. So don't take it lightly. Make sure you talk to your CPA before you make any decisions. And then finally, with respect to your entity and the idea of separateness and independence, remember we talked about that a minute ago, you need to make sure to keep a separate bank account for your business entity. You're working to keep your business as separate from your personal life and your personal money as possible. Do not, under any circumstances, commingle business and personal funds. Your business cannot be truly separate and independent if you're commingling funds. If you're sued by a creditor who is trying to reach your personal assets and you've been using a business credit card or account for personal reasons, a court might determine there is no real distinction between you and the business, and then you could lose your limited liability protection. This is called piercing the corporate veil, and you really have to be vigilant about maintaining the distinction between your business and your life, or you could find yourself in that position. And that means that your personal assets would end up being in play again, and you do not want that to happen. So now that you've avoided the first hidden legal disaster and protected your personal assets, we're going to assume that you're going to take care of this and move on to figure out how to protect your business name and thus your reputation and its integrity. So the second hidden legal disaster that can hurt your business is neglecting to register your own business name and logo as a trademark, a federally registered trademark. So think of Coca-Cola, Mary Kay, Domino's, Amazon, Google. What do all these companies have in common? They have a trademark in place that keeps any other company from infringing on their identity and products. Product names and logos can be trademarked. For instance, I have trademarks in the phrase "leverage a lawyer." If you have in all my businesses, if you have a unique tagline or slogan that can be trademarked too, for example, Nike's "Just Do It" and Burger King's "Have It Your Way" are both protected phrases because they've been federally registered. And finally, if you have unique trade dress, that is the appearance of a product or packaging, you can even trademark that. So Tiffany's, for instance, has trademarked the unique turquoise shade it uses for all its boxes. So keep in mind, and actually Intel has trademarked their sound. So the bum, 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 bum is trademarked because that is specific and unique to that brand. It's a way of identifying that brand. Just keep in mind that you must be offering something for sale in commerce, and that means across state lines, and that can also mean internationally, in order to qualify for a federally registered trademark. Now, you still could qualify for a state trademark, but that's not going to give you the protection you need if you're doing business with people from other states or other countries. And if you have a website, say you have an online retail site, or you sell items through Etsy, for example, or Amazon.com, then you are definitely making sales or offering products for sale across state lines. And in that case, you are in interstate commerce, as the trademark office calls it. And so you definitely want to get a federal trademark so that you're protected across the country and potentially in other countries as well. So and again, I'm going to greatly oversimplify this, and I strongly recommend using an experienced trademark lawyer to help you file your trademarks. I spend a lot of my time as a trademark lawyer cleaning up messes that my clients created for themselves by trying to go cheap and either use a LegalZoom service or something like it, or do it themselves. And 9 times out of 10, people come to me needing me to help fix the problem they created. It is not as straightforward as it seems. There's a lot of knowledge that you need to have to do it correctly. And so I can't stress that enough. But in general, there's a 2-step process involved in establishing full trademark protection. And you want to begin this process as soon as possible. The first step is to begin using the TM symbol after your company name, logo, or tagline. That's that little TM subscript. It puts the world on notice that you're claiming a trademark. And it's important to document the date on which you began using that trademark, meaning when you began making sales across state lines or internationally, or offering things for sale through your website, for example. If there's a dispute over trademark ownership, the trademark office will look to see who put the mark into use in interstate commerce first in order to determine ownership of the mark, or priority is what they call it. You must make sure that there is no way that your proof of trademark can be falsified. You want it to be the kind of thing that could be admitted into court and it will be considered, presumptively verifiable or or correct. And one way to do that, this is very old school, but one way to do that is print a copy of whatever it is you want protected. Maybe it's a screenshot showing your use on the internet, for example, and you can put it in an envelope, seal it really well, address it to yourself, and mail it to yourself through the US mail. And when you receive it, don't open it, just file it away in case of a later dispute. The postmark itself is conclusive proof of that date because the postmark has a date on it. So you can actually establish the date of use that way. It's very old school. Dated screenshots are a great way to do it as well. There's lots of other ways to prove dates, but that is kind of a little trick that not everybody knows about. You can also establish the date of use through dated printed materials, or even dated email, as long as it's not something that could be easily falsified. And I'm going to take a sip of water. Hang on one second. Okay, the second part in the trademark protection process is to file for trademark registration with the United States Patent and Trademark Office, which is the USPTO. And as I said, you can do it alone, but it is not as simple as it seems. And it is very possible and often likely that you will get a response back from the USPTO, either rejecting your application or asking for additional documentation or information. If this happens, I strongly suggest hiring someone to help you get through the remaining steps of the process if you didn't already. If you're planning on selling only products or services in one state, of course, file for a state trademark through your state government, like the state's Secretary of State's office. But as I mentioned before, if you have a website, you're technically in interstate commerce, whether you like it or not. And that means you really should apply for a federal trademark. And if you plan, and let me just say something about that really quickly, because if you don't file, and somebody else starts using a similar name or the exact name in another state, and then they begin expanding across the country, and they go ahead and file for the trademark, you're going to end up in a dispute over who has priority in the name. And while it may be something you can ultimately prove that you were using the name first, there are a bunch of reasons why a court might decide you don't own the name. And I don't have time to get into them right now, but it can happen and does happen. And so you have to be proactive about making sure that you protect your right to own that business name or that product name, or service name or tagline or whatever it is you're trying to protect exclusively. And the only way to do that is to get a federally registered mark. That is also the only way to have all the legal remedies available to you to defend and protect your rights if a dispute arises. And let me just say that even if you're in the right and you potentially could win, having a dispute will be expensive. We're talking hundreds of thousands of dollars, if not more, and it will take a year or more, potentially 2 years or more to get it resolved if you're in a full-blown dispute. And so it's not easy to get out of a dispute once you're in litigation. So you want to do everything you can up front to prevent that, and filing as soon as possible for a federal trademark is a really important step. I do have another webinar that we do on protecting your brand, and that goes into more detail about that. So if you're interested in more information on that, make sure you look for that virtual lunch and learn replay that we have on our website. One other thing, if you plan on selling your products or services internationally, you'll have to meet many additional requirements, and that process is quite complicated and will almost certainly need assistance from a lawyer. So make sure that you hire somebody early to help you navigate that. Okay, so we're now getting into the third hidden legal disaster that can hurt your business. And this one is failing to secure a registered copyright for unique materials. If you want your brilliant ideas to be your own and benefit you and your business, a federally registered copyright is really important. Many people think they don't have a copyright until they file for it with the government, with the US government, but that's actually not true. As soon as you create an original work, now it has to be original, and it could include anything from being a sales video, a teleseminar, a video, a webinar, even a PowerPoint, a portrait, architectural drawings, you write a novel, lyrics to a song, you name it. If you created it and it's original, you actually do already have a copyright. That is actually automatic. and it attaches to your work automatically. However, without a federally registered copyright, you only have limited remedies to protect that creation. So it's similar to a trademark in that way. So once you've written or created your original piece of work or whatever it is, you need to put if you've seen the little circle C, it's like a subscript for copyright, and your name, probably your business name, for instance, the little circle C, which stands for copyright 2017 Leverage Legal Group. That would be a copyright statement for Leverage Legal Group for my firm. When you add this to your original works of art, you can put it on your website, you can put it in your PowerPoints, you can put it on, watermark your photos. When you make it clear that you have a copyright in whatever the item is, it puts the world on notice that the material is yours and cannot be impermissibly copied without legal consequences. Next, again, I really want to encourage you to hire a lawyer, like at Leverage Legal Group. But even if you do it yourself, you need to fill out a copyright application and file it with the Copyright Office. And you will attach a copy of the item you want protected. And a digital version is usually sufficient that you can file online. You're going to pay a small fee. The copyright fees are much less than the trademark fees are. And then you're going to wait, because it can take up to a year to get notification of your registered copyright. And you may get rejected. But if you hire a good copyright lawyer, hopefully you won't. But once you apply for the copyright, you do get provisional protection. And you do that also with a trademark, just until a decision is rendered on the file. So you want to get your application filed as soon as possible. And so while you're waiting for approval of that copyright, continue to use that copyright symbol and the year, as well as the holder of the copyright, which is either you individually or your business, depending on your situation. Again, a lawyer could help you determine who owns the copyright. Add the words "all rights reserved," and you have a really solid copyright statement. One thing you need to think about, whether you want to own your own intellectual property as an individual, which then will make it a personal asset, or if you want your company to own it. Now, generally the company should own it. There are some instances though where people will set up a holding company to hold assets, and then a separate operating company to keep operations separate from the assets. And it can get very complicated, but there are reasons why you might want to do that. And there may be reasons why you might want to personally own your intellectual property, like trademarks or copyrights. Again, talk to a good lawyer about this, because these are really important decisions that, unfortunately, for most business owners, you don't understand the importance of them until you end up in a dispute and it's too late to do anything about it. And so just know that if you get sued for your operations and your assets are not housed in the same entity, they're not going to be subject to judgment the way they would be if they were housed in the exact same entity. So that may be one reason to keep them separate. But if you want to sell your business in the future, then you need to have the entity holding your intellectual property, your copyright, your trademark. It's got to be the same entity, because those are assets, and no one buying your business in the future would buy it without the business owning those assets, because often that is what they're buying, is the intellectual property and the brand. And finally, this is really important, and most business owners do not know this. And every time I give this webinar, I have people really freaked out and calling us to help them fix this problem for themselves. But if you hire a third party to help you create work for your business of any kind, whether it's a copywriter, a virtual assistant, a web designer, a graphic designer, somebody who's designing your logo, for example, the common law rule, actually it's in the Copyright Act, so it's statutory, it's not just common law, is that the independent contractor actually owns the copyright in that work they created for you. Even though you hired them and told them what to do and you paid them, the Copyright Act says that independent contractors, if they're not a W-2 employee, they actually own the intellectual property in that item. Now, the rules have some exceptions that get a little complicated, but a good rule of thumb is to assume that your contractor might own the copyright in the work they're doing for you. And so to prevent this, you need to have that person sign, and this is a contract they need to sign ideally before they begin the work for you, but if they haven't, you need to try to get them to sign it after. a provision or a contract transferring their ownership rights in that item to you and your business irrevocably. Um, Otherwise, that person can use that creation or content or design in any way he or she wants, including selling it to another competitor or distributing it as his or her own work product. And in fact, I would use the belt and suspenders approach and have your employees sign the same agreement to make sure you're protected. Um, but the rule is really clear that if it's an independent contractor and you don't have a contract in place to this effect, the contractor owns the items. And so this is one, I mean, I sound like a broken record, but obviously because I've been doing this for a long time, I've seen so many heartbreaking situations where business owners attempted to, do the cheap route with the legal issues in their business, and they paid seriously for having made that choice. So I do not recommend drafting this contract on your own. Instead, I would ask your lawyer to draft what's called a work for hire agreement. We do that routinely for our clients, and we do have a template for it in the Leverage a Lawyer website. Look under the contract template page at leveragealawyer.com. But ideally, you're going to have it customized to your own business so that it actually is going to protect you if there's a dispute. You can also make it part of a non-disclosure agreement, which is something you should be using with everyone who works in your business. And if you want to know more about that, stick with me, because that is the fourth hidden legal disaster to avoid. So we're going to jump to that now. And so the fourth hidden legal disaster that can hurt your business is failing to have every employee and every single independent contractor who works for you sign what's called an NDA, or a non-disclosure agreement. Okay, I'm going to take a sip of water again. Bear with me. Okay, an NDA is absolutely critical to protecting your ideas and your proprietary information. In fact, I just had somebody call me this week who created an entire business concept, spent a ton of time on it, hired a coach, a business coach, who is also a friend. It sounded like maybe it wasn't an ideal scenario all around, but did not have this person sign a non-disclosure or confidentiality agreement. And this coach actually stole the idea and launched the identical thing before the client could even get there. And because she did not have a non-disclosure agreement like the one I'm going to describe to you here, she really is going to be hard pressed to do anything about it. And it's heartbreaking when this happens. So I think of it as a tripod. The way you protect your intellectual property and your ideas and your assets is to have a trademark as one leg of the tripod, and sometimes you're going to have more than one trademark. Your copyrights as another leg of the tripod. Maybe it's a stool that you need to sit on, right? So you got to have solid three legs. Your non-disclosure agreement, and it's more than just about non-disclosure, and you'll see as I describe to you what I normally do. That should be the third leg of your stool or your tripod. You are absolutely not fully protected unless you have all three in place. So the NDA basically says that the person working for you, who is going to, by the way, get access to proprietary information and confidential information just by nature of working with you, they cannot disclose or distribute in any way or share with anyone else the confidential and proprietary information that they learn as a result of working with you. It's going to protect your email lists, your client names and contact information, and any kind of business plans you have for the future, products or services that are in development, financial information, branding campaigns, anything else that pertains to your business, passwords, all of that. I call it letting someone behind the curtain of your business. When they start to get access to any or all of that, that's where the danger begins. And so I personally will not let anyone behind the curtain in my businesses without first having them sign one of these agreements. And this is super important, if somebody balks at it or won't sign it or gives you a hard time about it, that is a massive red flag, and I will not hire them. Walk away, because serious business people understand the importance of this and sign them routinely. Now, investors will not sign them, so don't think that a venture capitalist or an angel investor will sign one Generally, they're presented with way too many deals. Um, and some businesses don't need this, of course. So, for example, if you're a life coach, or if you're hiring a life coach or a mentor, um, they likely won't sign an NDA. If you serve in that role, you likely won't sign one, but you still want one for your employees. Um, and So there is a bit of a fine distinction when you're getting advice from people, but you need to be really careful about what you're disclosing if they're not under that type of agreement. And anyone working for you absolutely should sign one. Um, and I usually include within that non-disclosure agreement non-competition language, non-solicitation language, so they cannot start a competing business, and they cannot solicit clients or employees or contractors away from your business either. Those usually these provisions have to be limited in scope. They can't be super broad. They can't last for a great period of time. So again, this is the reason you need to hire a good lawyer, to make sure that you're not running afoul of the enforceable rules. Because sometimes when you go to court, if your contract is too broad, a judge may say, it's too broad, I'm going to strike the whole thing down and not enforce any of it. And so you want to make sure you have a good lawyer advising you so that your scope is appropriate and enforceable, so that you have some protection. Okay. The fifth hidden legal disaster in your business is failing to include proper documentation and disclaimers on your website. So your web designer is in charge of making your website polished and professional and representative of your business's unique image. But you do have one critical responsibility with your website that the designer is not in charge of. And there are actually people who will surf the web who are really litigious, meaning they want to file lawsuits and try to make a quick buck. And they're looking for quote unquote deep pockets. So they're looking for someone to sue. Having the proper documentation on your website can deter some of this dangerous behavior. And it's just generally going to prevent disputes. The two most important disclaimers to include are the terms of use agreement and the privacy policy. And sometimes you also need to include other types of disclaimers, like an earnings disclaimer. If you're a weight loss company, you might want to say, that everybody's results are different, and it depends on their amount of exercise and what they're eating, and you can't make any guarantees. So it's very specific to your business, but having a disclaimer might be necessary. And using the terms of use agreement, the privacy policy, and the disclaimer will greatly help minimize trouble from people using, visiting, and accessing your website. So the terms of use agreement is actually an enforceable contract. It sits on your website under a tab. Usually it's in the footer. And sometimes it will say terms of use. Sometimes it will say terms of service. You can also just put the word legal. But that generally is where people expect to see that. And if you click on the link, it's going to open its own page on your website. On many websites, it is really at the very bottom in small print. That's really sort of the trend, but it needs to be somewhere that people can easily find it and access it. And the terms of use agreement spells out in detail the conditions upon which somebody's going to access and use your website. If your site contains copyrighted content, offers any kind of advice, or sells products or services, a terms of use agreement is a must. What needs to be in it depends on your business. So again, this is where you need a good lawyer. For example, I have a golf clothing line called Grace and Game, and I sell clothing for women inspired by golf and the country club lifestyle. And if you sell clothing on your website, you need a terms of use agreement that governs the terms under which customers are actually making purchases or purchasing items from your website. So for example, it might say something like, the colors that are on your screen may not be the exact color of the item you receive, and we're not responsible for this disparity. Or you may need a disclaimer that you don't guarantee that you'll always have the size or inventory of a particular item, or that prices will change without notice. On my law firm website, which offers professional services, the terms of use might include a statement that no attorney-client relationship is formed by the mere use of our website, or by the mere act of sending an email to me, or using the contact form on my website. if you have any type of fiduciary relationship to a client, you need to have that kind of disclaimer in your terms of use. If you have a blog or a site that allows for social interaction, people can talk to each other, they can upload stuff like an interactive forum, then you need to have a terms of use that governs those activities and does things like reserves your right to exclude people from your website without liability within your sole discretion. So no matter what your business is, you need to give some thought to what you might be exposed to liability wise, and then add those to the terms of use agreement. Retaining a good lawyer who knows how to draft these is imperative, in my opinion. And as an alternative, we do offer some templates on Leverage a Lawyer, so you can check that out. But those are very broad and cover a lot of different things. Generally, that's sort of a catch-all, not ideal. And so I really encourage you to spend the money on a good lawyer to draft one that's going to really be specific and customized to your business. The second thing that you need clearly posted on your website is a privacy policy. And this is particularly important if you have any kind of forms on your website that collect personal data, such as email addresses or other personally identifying information from visitors. So if you have an opt-in box, for example, where you give away, a free something in exchange for their email address, or they sign up for your newsletter, you need to post an abbreviated policy right below it, like in the box, saying what your policy is. For example, you never share information with third parties, and that should also little phrase should be a live link that people can click on. It will take them down to the detailed privacy policy, which should sit right next to your terms of use tab on the bottom of your website. I'm getting some more water. Hang on one second. Okay, privacy policies are essential not only to protect you, but to build trust with your customers and clients. And we've all seen, the privacy faux pas that have happened, with Facebook and with Target and other big companies in the last few years. And it's obvious in how people react to those things that people care passionately about their privacy. And they really don't take it lightly when you use their personal information in an unauthorized way or a way they did not expect. So in order to build trust, this is not really a legal thing, but it's really about being a smart business person and building good relationships with your clients or customers. You really need to have a clear policy about how you're going to use the information you gather from them. And then you need to make sure you live by it. So if you say on your website that you don't share their information with third parties, you better not ever sell your list to anybody or any of that information. Breaking trust with that can cost you your clients and your reputation, which can be very, very hard to recover. And as I mentioned briefly, the final sort of important disclaimer to include on your website is one of the ones that I talk about is called an earnings disclaimer. This is a good example. If you have testimonials on your website, particularly those that promise a certain type of product or financial outcome, it's good to have a disclaimer on your website that basically says you can't guarantee results, right? You can't guarantee financial results or health care or weight loss results or any other kind of positive result. That way people cannot come back and sue you if their use of the products or services does not match those portrayed in the testimonials or if their outcomes aren't the same. So these 3 legal documents are an easy thing to include on your website, and they will save you a lot of trouble. So that you can focus on serving customers and our clients and providing the best business possible and not just fending off lawsuits. Okay, we're making good progress. We're getting there. The 6th hidden legal disaster that can hurt your business is not knowing or following the federal rules pertaining to email communications and disclosures. So despite the First Amendment, free speech really does have its limits. So you can't yell fire in a crowded theater, and you cannot email someone who does not agree to be emailed in a commercial setting. You cannot send a commercial or a sales email to them. If you send out email communications to your customers or clients, you have no choice. You absolutely must adhere to what's called the Federal Can-Spam Act. Or you could find yourself being prosecuted and fined heavily for being a spammer. And can spam does not mean you can spam. It's actually the opposite. It's an acronym for the name of the act, but um, it is an act that prevents. It's an act that prohibits spam. And this is really no small thing. I had a client almost go out of business a number of years ago because he was embroiled in litigation with the U.S. Attorney's Office out of New York for violation of the Can Spam Act. And the penalties for violating this are pretty stiff. Um, I think at this current time, it's about $10,000 per violation. So if you have a list of 1,000 people, imagine how expensive that gets very quickly if you're found to be a spammer. So now that I've scared you, how do you avoid this problem? Basically, you need to have clear authorization to contact someone via email. And the way you do that is to only add someone to your email list who's given you explicit permission to do so. And the best way to do that is with an opt-in box on your website where people can choose whether or not they want to opt in. I've seen some dialogue about this out there actually for years in social media. For example, Facebook. If someone friends you on Facebook, do not go in and find their email address and their info and then add them to your list. And it's really bad. There's a lot of people who do this, and it's illegal. It's not just bad, it's a violation of this statute. And there are people who are getting angry enough about it that they just might report you. And as I said, there's a per violation fine associated with this act. So if you have a decent sized list, you could get fined for hundreds of thousands of dollars. This client I had, it was a multi-million-dollar dispute with the U.S. Attorney's Office because he had such big email lists. So it can add up very, very quickly. So just don't do it. Let people opt in, let them opt out very easily, and make sure that they can find a way to opt out and that happens instantaneously. Obviously, the best way to do this is have a service manage it for you, like MailChimp is a good example. There are others, but these programs provide, they keep a database for unsubscribe requests. And so they create basically a do not contact list for you so that you don't inadvertently send an email to somebody who's already opted out of your list. Your website must also follow the Federal Trade Commission rules, the FTC. And in December of 2009, this has been a while ago now, the FTC began to enforce revisions to the guidance that it gave to advertisers. And by definition, if you're advertising anything for sale, you are an advertiser according to the FTC. And so if you put testimonials on your website, like somebody had a great experience with you and they want to share it with you, and then you put it on your website, you're actually subject to FTC guidelines, and you must disclose your connection to those who are praising your products, as well as disclaiming that results in the testimonial are not typical. And you've got some documentation requirements that go along with that as well. Drafting these disclaimers can be a little daunting because the FTC has just instituted this rule. It was 2009 when it was passed, but the enforcement has been sort of inconsistent, and they have not given a lot of guidance on it. I do have an instructional audio on the Leverage a Lawyer site. You can go get some help on that. As time goes by, the exact requirements of the rule will become more clear because people are going to basically get busted, and we're just going to get more clarity from the FTC on what it means to be in compliance with these rules. But for now, the very best thing to do is just clearly state that you cannot make any guarantees about your product or services. And this is best placed, as mentioned before, under that earnings disclaimer that we discussed under number 5 above, as well as testimonials. And I'd also include this disclaimer in your email communications, especially if you're using testimonials there. And then finally, you're required by the FTC to disclose affiliate relationships. Affiliate relationships are that's a relationship in which the recommender, someone who's recommending someone else, gets paid by the product or service provider to make that positive recommendation. And many business people use affiliate relationships in order to spread the word about their products or services. Amazon, that's their entire business model, is affiliates. They have a ton of affiliates directing traffic to the Amazon website for sales, and they make a commission off of those sales. And the FTC is really cracking down on this. The IRS has been as well. That's a side note. But they don't want the public to be misled with these recommendate or with the work of the affiliate relationship, because if you're getting compensated, you're more likely to make a recommendation that maybe isn't based in fact, and they don't want people to be misled or manipulated. And so, how could an affiliate relationship mislead a customer? Well, it's simple. When someone raves about a company, um, if that person is getting paid to tout the product or service, it might affect the recommendation's credibility. So the FTC is saying you need to disclose paid recommendations and affiliate relationships. So if you use or are involved in an affiliate relationship, just make sure this information is clearly posted. You don't want there to be any confusion about it. You can use boilerplate language such as, in some instances, this is a quote, in some instances, I will make a recommendation for which I am compensated. However, I will never make a recommendation for something that I don't believe in or haven't personally experienced, period. That way people know you're getting compensated, but you're sort of minimizing the negative impact of that paid recommendation on that sale, on the, convincing them to make the purchase, because you are going to get paid for it. So err on the side of being safe with affiliate disclosures, email lists, and advertising disclosures, because again, the business community is not exactly sure how the FTC is going to enforce this in the coming years, and you don't want to be the one they decide to make an example of. All right, we're to number 7. The seventh and final hidden legal disaster that can hurt your business is failing to have a contract that governs each and every relationship within your business. This is a massive topic. It's so important. But if you're hiring vendors, have a retainer agreement with that vendor. Make sure that the contract governs the price, payment, or fee of the relationship, the time period the relationship covers, and very specifically what the parties are agreeing to do for each other. And then have all of this information clearly written out. If you're bringing on clients, have them sign a detailed retainer agreement. This agreement is a great communication tool. And unfortunately, it's an area that so many entrepreneurs skip. I hear this a lot where they think it's overkill, or they're just getting started, or they think a client will be offended by the suggestion that you need a signed contract to trust them. However, true professionals and business owners understand the need for a retainer agreement, and they're not going to give you a hard time about it. In fact, they probably wouldn't agree to do business without one. And the beauty of a retainer agreement is that it's going through the process of negotiating the agreement. By doing that, you're going to set out really clear expectations for everyone in the relationship so that everyone knows the scope of their role and their exact responsibilities. It also governs what happens in the event of a dispute, which is very important because it is really hard, once you're mad at each other, to come to agreement on how things should be handled and resolved. And so a good contract will do that for you ahead of time, so that if there's a dispute, you're not going to end up fighting in litigation for years. So it's better to go through the awkwardness and the difficulty of negotiating an agreement on the front end. So make sure you're doing this. Contracts do make some people uncomfortable, and they might become sensitive or insulted, just like you perhaps would be if somebody presented you with a prenup before you got married. If you're afraid of offending someone, try to think of it in a different way. How someone responds to your request that the relationship be governed by a well-crafted contract is really a test. It's a litmus test for the relationship. Because, as I said before, a true professional is going to understand why it's important. In fact, they're probably going to insist upon a contract. It protects them too. So if someone balks at it or gets offended, that's a huge red flag. And I really encourage you to run away from someone like that. It's going to save you a huge amount of heartache and money on the back end. Okay, so now we've gone through the 7 hidden legal disasters that can hurt your business. And as you can see, they're all easily avoided. If you've already started your business, don't panic. It is not too late to take any of these steps. Take a deep breath and tackle a few of these issues at a time. Get a good lawyer on your team, file for your entity, take steps to copyright and trademark your work and your business name. Make sure you have strong, solid contracts with your employees, staff, vendors, and clients. And make sure you're using disclaimers liberally, and be super careful who you email. A strong legal foundation is the cornerstone of having a brilliant and successful business, and it is an absolute necessity for protecting your assets and assuring you peace of mind. So I know some of you are going to have questions. I am going to post some answers on our website that are FAQs, frequently asked questions and answers relating to some of these topics. So make sure you jump over to our website and look for those, because I suspect we'll answer some of your questions in those. Now, if you have a question that you'd like to ask us, you can always email us at support@leveragelegalgroup.com. You can also set up a 30-minute free consultation with us. It would either be with me or my business partner, Candace Owens. And we have an amazing team, incredible staff and lawyers. And so if we can assist you, we would be greatly honored to be able to do that. To get more information on us generally, just go to our website. It's leveragelegalgroup.com. And if you're interested in our templates website, it's leverage-a-lawyer.com. I really hope I get to hear from some of you. You could also jump over to our Facebook page, which is Leverage Legal Group. It's facebook.com/Leverage Legal Group. And feel free to post questions on the wall. We also have weekly virtual office hours on there. And you're welcome to post questions on our wall, or you can private message us if it's more sensitive. Just make sure that you don't share confidential information on our Facebook wall, because obviously that's public. Other people can see it. And remember that just by emailing us or private messaging us, it doesn't create an attorney-client relationship, because we would have to do what's called a conflict check to make sure that we can even take you on as a client. So don't tell us too much until we're able to have a conversation. But we can answer some general questions and then set up a free consultation call for you if you have questions. So thank you for joining us, and I really hope I get to speak with some of you and work with you in the near future. Good luck.